Your speakers are going to be talking to you about real estate, land use, zoning, and building. My first lady right here is Tedrow. She is a shareholder with Lowndes and the chair of the Cannabis and Controlled Substances Group. She's going to be your moderator. Then my next lady is Alicia Lewis. She's a member of the Land Use and Zoning Practice Group at Greenspoon, Marder. Then we have Mark Gemignani. He's the founder and president of Dominion Builders, a privately owned national general contracting company that's based here in Miami, Florida. Then we have Scott Allen last over here, senior managing director at Tower Commercial Real Estate, a full-service commercial real estate brokerage firm in South Florida. I'm going to let you guys go ahead and get started. Enjoy.
Good afternoon, everybody. Is this microphone on? Can everybody hear? It was a little hard to hear in the back, so I just want to make sure. Wonderful. We're glad to have you today to talk about the real estate trends, what's going on with building, and the issues that you need to predict if you are trying to get into any portion of this business when it comes to opening up a business as a dispensary or for cultivation and processing facilities. So we have a wonderful panel to be able to talk about that. The first question we want to talk about is basic zoning regulations. And so just to set the stage, when it comes to Florida statutory law, the really only zoning regulations you need to know, you can't be within 500 feet of a school, and the state says that local governments have the right to treat dispensaries like pharmacies or to ban them outright. So from that perspective, I want to hand it over to our panel. When looking at zoning regulations, to what degree and how frequently do cities and counties add another layer of regulations with their ordinances that people should consider?
Good afternoon, I'm Alicia. I'll go ahead and start with that. I'm a land use and zoning attorney at Greenspoon, Marder. I would say it happens very often. I actually practice in the Tri-County area, and one of those cities that's within that jurisdiction is Deerfield Beach. Deerfield Beach actually specifically changed their regulations for pharmacies because they looked at it as though, okay, we'll opt in and we'll allow medical marijuana facilities, but we'll limit them by specifically making sure that pharmacies won't continue to grow in our city because we have enough of them. So that's exactly what they did. So they limited it. I think there were only maybe two. I'm not sure if anyone else knows exactly, but maybe 2 facilities that were able to open because of that. So they specifically targeted limiting how many facilities could be there.
That is a very good example, actually. And there were, Deerfield was an allowable municipality. They allowed a couple in. And then what made it most interesting to the question that we're talking about is a few more wanted to get in, and they grandfathered the last couple in, and then at the same meeting, they cut it off. So no more, Deerfield Beach is now closed. So to answer the question from my perspective, is that they were either allowed initially or they basically put a moratorium, where I feel like now that if they had a moratorium yesterday and they started to open, that's when they started to put the layers on. Distance separation from pharmacies, distance separations from churches, parks, other dispensaries, further distances, 500 feet to 1,500 feet. So it has made it more difficult from the municipalities that opened it more recently. And maybe as an example, City of Hollywood here in our backyard, where it was banned and they opened it, they could be 1,500 feet from a pharmacy that was less than 6,000 square feet, plus 1,500 feet from schools, plus, and all of a sudden it made it micro pockets as to where you could even put a dispensary, which is basically all of a sudden 1 or 2 open up, and it basically blocks out the entire municipality.
Yeah, so it's gotten extremely complicated legally, because technically they're not really allowed to circumvent the laws that were set out by the Florida legislature. They've just gotten very, very creative with the local ordinances, like you've been talking about. In a lot of cases, they are doing things that are illegal, and a lot of them are getting disputed.
Yeah, the interesting part about the Deerfield Beach ordinance is they were reactionary. So they continued to change their ordinance in light of new dispensaries coming in and requesting business tax receipts or change of use permits or other general site plan approvals. And then Deerfield Beach at one point put out an ordinance that said if you want to open up a dispensary, you have to be an ancillary use inside of an existing commercial use. which I reminded them that we could not do that under the law, that there was no way we could go in and operate a dispensary the same way you have a pharmacy inside of a Publix, that they weren't going to allow that and no other principal commercial use based on security requirements. Could we ever have that in the city of Deerfield Beach? They wholeheartedly agreed. I ended up pulling that ordinance, but those are the types of problems that you deal with. And I think a good lesson that comes from this is when it comes to zoning regulations, local governments have the authority to change them at any time. And so a lot of people, and this is not just in the cannabis world, think that a zoning verification letter vests you for a use, that you now, because you have a zoning letter, have a right to open up a specific use. But if you read those letters, often they have a date in which they expire, so the letter is only good for 3 months or 6 months after it's written. They will often say the specific caveat that it does not vest you for any use, which means people will take a zoning letter, think that means they are good to go, put money in, buy a piece of property, go to pull their site plans, permits, or whatever approvals they need, and be turned down because the local government has enacted an ordinance to stop that use. So really important that if you get a zoning verification letter, that is not the end. You have to continue to monitor the politics in that local government and to make sure that they aren't proposing modifications to that ordinance or to that use you have a zoning verification letter for.
And virtually every license holder has learned that lesson the hard way by having it and says, I'm good to go. They put it in their pocket and either move too slow or just the municipality changes it at the 11th hour. So it has been a expensive learning lesson for many of the license holders.
Yeah, so look at what happened to MedMen on Miami Beach. I mean, they signed a long-term lease, and the city decided to change the distance separations and basically blocked them out after they had already committed.
And I'll also just add another layer. Even if you have a site plan that's approved, to say you are building something new from the ground up, a site plan is only good for a certain period of time as well. So if that site plan expired, say, it's typically about 18 months. So say your site plan expires and they change the zoning regulations, you now are in a position where you really were at the finish line, but now, what you are planning to build may not be possible.
And thanks for bringing up the example of MedMen. That example in the city of Miami Beach, it's fascinating from a legal perspective and horrifying for the end user because they were into the second round of building permit comments, meaning we're not talking about just having a zoning verification letter. They were well in over $1 million invested in site build out and were about to get full building permits. And then the city decided that they were going to enact an ordinance that would effectively prohibit them from opening up. And because they hadn't actually pulled final building permits, that pending ordinance applied to their property and did effectively shut them out, and hence the litigation that ensued from it. So those are the types of lessons learned, that zoning verification letters are typically not worth the paper they are written on, but the Department of Health will absolutely require that you have that zoning verification letter in order to be able to open once you've built out and are seeking dispensing approval. On the build-out side for processing and cultivation facilities, a little bit different, right, Mark, because the state gives more permissive regulations in the sense of there is no zoning over a cultivation and processing facility. That is specifically preempted to the Department of Health. So if you get your plans approved, the zoning department isn't reviewing them at all. So you can basically do whatever outside of code. It's just Florida Building Code and Florida Fire Safety Code that apply.
Yeah, so in a lot of cases, the cultivation facilities are built on inexpensive agricultural land. Mm-hmm. And it's like a dream come true for a developer. A lot of times there's no requirement to even get approval from the building department. A lot of times there's no requirement for fire life safety, like you said. Generally, it's just getting approvals from the environmental departments, just to make sure that you're not dumping chemicals or nutrients on the ground.
Yeah. Have you seen any other issues from a land use perspective when it comes to cultivation and processing facilities that are worth noting?
I worked on a site in unincorporated Dade County, and one of the biggest issues we had was water permitting. So going through DERM and going through different departments to get the additional services needed in order to have a functional facility. So, I mean, it just depends on what you're permitting specifically, but you could run into some environmental permitting issues as well.
In a note on development of cultivation and processing facilities, it's interesting because in the early days of this market, 2014, 2015, those build-outs were done with agricultural exemptions. These were bona fide agricultural lands and uses prior to marijuana companies getting licensed. And so they were building without having to pull any permits whatsoever. law changed in 2017 to say that you'll need permits in the sense of Florida fire safety and Florida building code compliance. But those other facilities, thank you so much, that were built in the early days of this industry were being built in 30, 45 days. No permits had to be pulled. And now you have the problem where your property taxes are a huge issue. And most people don't realize that these former agricultural lands that might have had very low tax rates on them, if your property appraiser takes an income approach to value, you may now be looking at 10 times the amount of taxes on that property if you apply for an agricultural exemption. So we've seen this and have, in some instances, 5 different property appraisers across the state actually pulled our request for ag exemption because the property appraiser said it's going to cost you, and we're going to value each acre at $1 million. That's going to be your income approach to value on the assessment we'll render. So you won't be paying $13,000 anymore. We're going to charge you very high 6 figures in taxes. And so that's something to take into consideration too. And unfortunately, there is no coherent response that comes from the state level on how property appraisers should classify uses. Because, and Mark, you can talk about this, these uses are often under the same roof, right? Yeah, so that makes it difficult from that perspective as well. So
I've actually fought agricultural exemptions being denied, and I think I'm pretty good at what I do and don't take too many L's, but that's one L I took because
Yeah.
it was very, so they do not budge. You have to think it's the property appraiser. They're not going to budge with you when it comes to whether or not your property is exempt from being taxed. So please keep that in mind. That's very, very important.
what was the specific issue in that case that they had?
So it was an issue with showing that it was no longer going to be used to keep horses. It was an agricultural property that was being used to keep horses, and they gotten down to maybe a third of the horses that they were keeping, and the property appraiser just wasn't convinced that they were showing enough use of the land for that specific agricultural use. So they went from having absolutely no issue and having a huge issue because they now weren't able to show that they were using it for that agricultural purpose.
Scott, this next question we can start with you on. What difficulties are you seeing from a real estate perspective on finding properties for dispensaries, probably for the most part, but just properties generally for the cannabis industry?
No, it's the word's barriers to entry. That is the biggest problem, and it literally is not even a real estate search. It is a research project because you really have, number one, am I allowed to be in that municipality? If I'm allowed to be in that municipality, does it have the zoning? And if it has the zoning, does that property, if I'm going to go buy it or lease it, or if I'm going to lease it specifically, is there a loan on that property? Can't go in there if there's a loan on the property. Also, there's restrictive covenants. If there's any our big anchors, a Walmart, a Target, a Publix, anchored shopping center, none of the restrictive covenants 99 out of 100 times are going to let you go there. So you lump all these things together, and it becomes finding a needle in a haystack. So in the municipalities, they didn't even allow it, and then even goes back to our other statement, the ones that are starting to open are putting restrictive covenants. And there is distance separations that are required from, again, even if it's just the state mandated, it's 500 feet from secondary schools, but then all the municipalities are starting to lump on lots of other things, whether it's a park, whether it's other dispensaries, whether it is a pharmacy. So it's become troublesome, and the fact that we sit here today we're coming up on 200 dispensaries in the state of Florida, and again, as we sit here, that is only about 25% of what's allowed. So now think the municipalities are making it trickier to get in and tougher to get in. We're only at 25%. Now when there's 400 dispensaries, go try and find a location in any respectable area that you want to be in on a major retail thoroughfare, and we feel like it's going to start to get harder, to say the least.
So they're almost impossible to come across, correct? So what's happening?
Closer, getting there.
You'll probably have a better feel for this than me. What's happening to the value of these locations?
Well, that is definitely a big problem. People, you have, John Smith in Anytown, Florida, and he finds out that his building is, former restaurant, former bank branch, sits in a municipality because his phone's been blown up 6 seconds after it hits the market, and all of a sudden he finds out that he thinks he's sitting on a pot of gold. So it is, in some cases, yes, in some cases, no, but it has been difficult, and we have. even our company, as a principal of the company, we've set up a fund even so we can, for all intents and purposes, hide what we are doing and buying the property, so we're able to work with our respective clients and at least sell it to them at a market-oriented number versus getting severely gouged, which has happened, and where the kind of the A++ sites around the state have really been commandeered already. And so now you're having to really be creative, whether it be an unanchored shopping center or a freestanding building.
Alicia, what are you seeing with your clients on that side of things, with the difficulties of just the transactional aspect outside of the zoning regulations?
I think that one of the issues that I've seen a lot is not fully understanding the process that you may have to go through in order to actually open up. And I think that's just something that's really, really important, is to really educate yourself on just the overall process.
Yeah, and one of the difficulties too with financing these transactions, obviously we have limited traditional financing options, hence we have to find properties that aren't encumbered by mortgages or traditional financing, and then title insurance. There are maybe 2 companies that underwrite title insurance because they take the approach that they cannot insure marketable title because your use is federally illegal, to which we remind them we're not asking you to insure title on our use. It is on just the title to the property itself. And so it is a strange situation, but Westcor and Alliant and a couple other title companies are willing to underwrite. So look at your contracts. Make sure you're not putting in, the Fidelity National Title Insurance underwriters of the world, because they will not underwrite when they know that it is or may be used for cannabis purposes, which is a very broad prohibition in that industry. So title insurance is big. And then escrow agents, even if you can get them to act as their title insurer, they often will not act as an escrow agent for your closing. So then you have to go out and find another third party who's willing to act as an escrow agent. And so those are some of just the difficulties from a transactional perspective. Mark, what are you seeing in terms of financing in this industry on the cultivation and processing sides? Anything different?
No, there's just that there's not a lot of debt out there available. Most of our clients are either 100% or 90% all equity-based. So it takes a lot of money to raise enough money. You got to raise a lot of money to build one of these things, and then they have their ongoing operations. So you're talking literally hundreds of millions of dollars having to be raised to start a large-scale cannabis firm.
Scott, what are you seeing as those A+ properties that cannabis companies are looking for? I mean, is there a magic recipe to what they want?
Magic recipe. There are lots
Fully
of traffic.
entitled.
Yeah, exactly right. There are lots of things. Being on the right corridor, and it almost doesn't matter if you're talking the first tier, Miami's, Tampa's, Orlando's, Jacksonville's, or even you get to your Ocalas of the world. Then it falls under your typical where your Walgreens and your McDonald's wants to go, where high traffic counts, the right income, easy access to the property. We have a major problem with parking, and that is because we're treated as a pharmacy. That often will bite a lot of people. So it's, again, by and large, with any of the open markets today, a lot of those have been scooped up, and so everybody's keeping a very, very close eye on something that does come up, or a municipality that may open up.
And I was just going to add that keep in mind that retail is shrinking. With Amazon and the growth of people getting things shipped to them, retail spaces are going to be a lot more limited in their availability. So thinking of new and innovative ways to develop certain properties that maybe you wouldn't have typically looked at as a retail space or a retail front is really important, because you're going to see, as we continue to grow as a nation and as a society, that these mom and pop shop storefronts aren't going to really be available.
Mark, what are you seeing on the cultivation and processing side in terms of an ideal property? I mean, is it access to power, natural gas? I mean, what are you all looking for?
We're looking for, like I said, access with regard to distribution, access with regard to utilities. These facilities use a lot of power, use a lot of water. In Florida, not so much gas, but some of the northern climates, gas is really important. That's really it. And again, the agricultural land is really the place for these to go.
And not to give you a totally shameless plug for the specialty that you all have, but why is it so important to work with companies that have done these types of cannabis-specific build-outs for processing and cultivation, and not just use any general contractors or companies that can get you a lowest bid?
Well, this is a very specialized business with regard to design and construction, it's almost imperative that these projects be completed with a design-build approach because it needs to be an integrated process. The procurement needs to happen before the construction is started and before the design is completed, so you need to be buying things, incorporating them into the design while the process is moving along. And you need to have somebody that understands how all those parts fit together.
And to build on something that you were talking about, Scott, with that A-plus retail, one of the interesting aspects of the settlement in the spring that the governor settled and 8 new licenses were awarded, part of that settlement required that 10% of the properties that MMTC is able to open up, that those dispensing properties specifically have to be in zip codes that are 50% below the state median income level or rural areas of opportunity, and 50% below the state median income level is about $25,000. So those economically disadvantaged areas, now 10% of the total dispensary count is going to have to go in those areas. Is it safe to say that's going to be challenging for them to find prime real estate spots in those areas?
Sure, and we added to our process of our list as we're talking about. It's very specialized. We literally, my team has spent the last 2.5 years specifically learning, we have spoken to almost every municipality in the state of Florida, obviously ones that are open, not so interested in talking to ones that you're not allowed to be in. And so, and whether they want to be on Main and Main or they need to comply with certain governmental regulations, throw it in the pot and do what we do and put the specialized hat on and go find that location. But there's no doubt it is going to be difficult. And even what Alicia was talking about, the retail, everything you read in the paper, retail's dying. Well, good luck. Go try and find a decent piece of retail real estate at any market-oriented number. And it is quite eye-opening and not the case whether it's cannabis related or not. So now try and overlay everything becomes difficult, and then try and find some of these the zones that fit under the new policy makes it that much more complicated.
Alicia, have you seen companies running up on those dispensary limitations that are imposed by Florida statutes yet?
No, not really, but I think it's just because of the bigger companies that were able to really get in and make their mark. So not yet, but I can definitely see an issue.
And for those who haven't gotten a headache reading Florida statutes recently on this, it provides that there's 5 geographical dispensing regions statewide that are broken down based on the demographic data of populations in those collective regions. And then based on those regions and the population size in the cumulative region, you are allocated a certain number of your overall dispensing slots that you can then open up. And if you want to sell one of your slots, you can then sell it to another MMTC, reducing the number you can have in that region. And you can also buy one from another MMTC, increasing the number that you could have in another region. So we're in the Southeast region, 11 are allowed here. And so here in the Central region are the largest areas of the state where you can open up dispensaries. So I'm sure, Scott, have you seen a lot of people rushing to come into the Southeast and rushing to get into the Central regions because of that?
It's all of the above. They know it's allocated, spread out throughout the state, so they're conscientious of it, and they do. It's like once in a while you'll be sitting in a meeting. It's like, oh, how many do we have? How many do we have in the Central again? How many do we have in the Panhandle? And so they're conscious of it, and we've seen some move around. But it is interesting that you start digging into it a little bit, finding out that it's not just 35 dispensaries. It's 35 dispensaries in specific areas around the state. So it just adds another layer to trying to solve for your problems.
And that dispensary cap expires 4/20, so I don't know if that was intentional on behalf of the legislature in Tallahassee, but next April is when that will expire, unless it gets replaced by a more ludicrous dispensary cap that also doesn't seem to make a whole lot of sense in implementation. So let's talk about the statement of when it comes to medical or recreational cannabis in this state. Is the pattern that there is no pattern?
Go ahead.
Between states?
Sure. Mm-hmm.
Yeah, there's really no pattern. It's actually starting to coalesce a little bit. But look at California with a wide open market versus Florida with a very tight market. It seems we work all over, and it seems that every new state that opens up is more and more similar, like the previous ones that recently opened.
So from the bigger picture, Florida, yes, took something out of somebody's book and put the 500 feet from secondary schools and so forth. But when you drill it down to the municipalities, there absolutely is no pattern. Right where we sit here, Miami, and you just go right up the coast. Miami's different than Aventura, that's different than Fort Lauderdale, that's different than Deerfield, that's different than Hollywood. Every one of those has a pretty dramatic different, and you can keep going right up the coast, you can go west, and they are different. So there's no rhyme or reason, and they kind of add little tweaks to their respective zoning codes as to what they feel like works. And that applies to the big markets like a Miami all the way down to an Ocala or an Avon Park or a Sebring. So it's not that even the small guys are follow Florida code. So it's literally in the last 2 weeks, there's been small municipalities in the middle of the state that said, look, our constituents want it, open it. Right down the street, it was open, it's closed. So it is an ever-moving target that it doesn't seem like it is going to change anytime soon.
And I know our focus is zoning and permitting for cannabis purposes, but keep in mind every municipality has different zoning regulations for all different types of uses. I mean, like if you wanted to build a car dealership, I'd tell you you can't do it in Miramar. Or if you wanted to do self-storage, I'd say you can't do that in Sunrise because they have codes, land development codes, that completely make it impossible for those things or those uses to exist within their jurisdiction. So once you get into land use and zoning and you're dealing with those issues, some of these issues come up across the board. So I would just say not to get discouraged. If there's really a property that you think is going to work and there is some means of making it work for you, don't get discouraged necessarily, because that could happen with a grocery store. I could be working on a Publix and have issues with getting it approved. So just keep in mind zoning and land use is very specific to a region and how people think, how those commissioners think, and what they'll approve.
Yeah, and the interesting part about that 500-foot separation from schools is Florida statutes doesn't define how you measure that. So all the local governments are making that up too. So you can go in and some say property line to property line, door to door, pedestrian path of travel. So everywhere you go, you have to make sure that you understand what that separation requirement is, because I've seen some people get separation surveys and they aren't measured properly, and then that company already closed on that site and they are within 500 feet of a school and won't be able to open because the local government will not waive those distance separation requirements, even though they have the authority to alter them under statutory law. So it's interesting just how much it continues to change, and you'll find too that local governments make it up as they go. So you'll probably pose that question for the first time to them, and they will get defensive and a little reactionary most of the time, and then go back and figure out what will not get them in trouble for what they tell a cannabis company or a cannabis attorney when they come in and ask you questions. Have you seen some effective ordinances that have been really well written, or ones that have been absolutely terrible? We don't have to name the local governments where you've seen them, though I'm sure some people could figure it out if you did.
Yeah, I personally, and I don't even have a lot of information to back it, but there's one of our major municipalities, and they established something very early on, and then it was X number of dispensaries per district. And so now all of a sudden, so from a governmental standpoint, people can go complain to the commission board, but they have abided by what the voters want and allowed X number of dispensaries in, and it's like, that's it. You know the rules of the game. You can try and get in, and then after that, we're cutting it off. So because, and I think it's a good thing, because all of a sudden I think Deerfield, because they were kind of surrounded by people that was a no, they're like holy smokes, we're going to become Green Row here with 15 dispensaries because no one can go anywhere near us. So that's the only place we can go, and they're like, well, we better slow down here. So I think no is the wrong answer, and I think maybe at an absolute yes across the board is probably problematic as well. So some variation. So I think the one I was speaking about, that it let X number in, I think is a pretty smart thing. You can go and get it. It's not very far. It can probably be delivered pretty easily. So I think that was a very good middle ground that they hit. It's probably a good recipe for success for other municipalities as they decide what they want to do.
I think a good lesson too is if you can get a good local lobbyist or a good lawyer, they can change those codes for you. Oftentimes it just takes educating commissioners, which I'm sure, Alicia, you can discuss as well, as educating them as to what the industry actually is.
Right, and that's very important. So before you submit any application, especially if there's going to be any particular issue with it, I always recommend meeting with local elected officials, especially if there's a vote that's going to be required. And in those conversations, I've often seen that cannabis clients kind of clam up because they just don't want to mess up and they don't want to say the wrong thing. But you're the expert. You are the expert on what you do. And we're here to educate, and we're here to make sure that some of the things that they assume will happen, we can clarify why they don't happen, and in your experience, why they don't happen. And so it's really important that you look at those meetings with elected officials as your opportunity to sell yourself as a partner within that community, and not to clam up and think, oh, I just don't want to say the wrong thing, or I just want to leave and they like me. Yeah, you want them to like you, yes, but you also want to make sure that they understand that they're standing behind something that they can honestly support. So.
Mark, have you seen any issues with local governments pushing back, or anyone on the panel, pushing back on cultivation and or processing centers and saying that they aren't properly zoned or they won't give you a zoning verification letter? Because even though it's preempted to the state, its Department of Health still asks for evidence of zoning approval from the local government for cultivation and processing, which puts you in a double bind in a lot of situations.
Yeah, we haven't experienced any issues here in Florida. But just in general, this industry is so difficult, so expensive, and so undefined that having the proper legal representation is the most important thing I think that anybody that's getting into it should do. They should really find an appropriate law firm that really is capable of handling all these things, such as yours, Alicia.
Shameless plug.
I was going to say, I was like, we
Greenspoon, Marder.
So let's talk a little bit more about the trends of real estate and what we see from the recreational market. What do you all think is going to happen if recreational is approved in the state of Florida when it comes to the real estate and how that'll be impacted?
Well, first off, whoever's in now in the medical market will have a huge leg up. I mean, they'll have their brand situated. They'll have their distribution in place. They'll have their cultivation figured out. So they're going to have a huge leg up on anybody else that's trying to get in.
I agree. I mean, I think when you know the lay of the land, you kind of know where it works, you're going to have that advantage. But I don't think that it should prevent someone else who's, maybe focused on the recreational portion from, entering the market and really, making a name for themselves. I think it's possible.
Agreed. For sure. It's, but I agree with what both said, but it's going to be, if they don't change, it depends. If they're changing any of the zoning or the license holders, and then that, again, they're coming in at the 11th hour, it becomes, or even after that. So it becomes pretty difficult.
Well, Make It Legal Florida, one of the constitutional ballot initiatives, specifically contemplates that the only players who could sell for recreational purposes would be those who are licensed for medical purposes. So if we have 22 companies and places like Oklahoma have 7,300 licenses, yes, we will have a much better chance of our 22 gaining some market presence as opposed to other, more diluted markets. But still, that means that from a zoning perspective, we don't know how the state is going to implement that constitutional ballot language if approved. Are they going to say that local governments have to allow the sale of recreational in any already existing dispensary? Are they going to say that local governments have full authority to regulate retail sales for recreational purposes however they want? Because if that's the case, or if there's a lack of clarity, do you all think that we're going to see some preemptive reactions from local governments banning medical marijuana dispensaries if they believe that that ballot could pass and now recreational could be sold in all of those medical dispensaries too?
When medical marijuana was first approved in the state of Florida, I remember seeing a draft of an ordinance, a smell ordinance, for a medical dispensary. So that alone, I mean, and they were really trying to quantify and decide how, far a smell could go. And just keep in mind that it's fear. I feel like what I do as a land use and zoning attorney is I manage fear. People are afraid of Walmart being in their backyard, but everyone shops at Walmart. People are afraid of, malls going away, but you just ordered 20 things on Amazon. So, I mean, it's fear, so you have to just keep that in mind, that like they're gonna zone things based on what they think people are afraid of.
From the ordinance perspective, back in 2015 when they were writing them, they were the most ludicrous ordinances you'd ever read. It'd be like, you have to sweep outside the front door of your dispensary twice a day. And I'm like, for what? I mean, we don't like open up the door and like toss handfuls of marijuana at people. Like, number one, they're all packaged oil products at that time. Shouldn't we mop outside the door twice a day? And they're like, fine, put mop. And I was like, see how ludicrous this is? I mean, why don't we just say you will allow them to operate? And I've even had at a public hearing a local government official say the reason we have setbacks from schools for dispensaries is the same reason we have setbacks for pedophiles. I just didn't get the logic. It was quite surprising, but that was the analogy, that this is the type of harmful vice, akin to pedophiles not being able to live near schools or go near playgrounds, which is why we need to separate dispensaries from being anywhere near schools. So you're 100% right. It is managing fear across the state and making sure people understand exactly what this industry is. Do you see any difference, though, Scott, from a retail? It seems like it might be easier for recreational, for retail storefronts, if they happen to be standalone and didn't have to be integrated into medical.
Yeah, I agree with that. Yeah, if you've got the medical already, you've got the establishment, right? You've got the name brand, everything there, from the grow to the distribution facility. Yeah, it makes sense. But like you said, it's what the government's going to do is up in the air.
What do you all see as the advantages and disadvantages of companies that are playing by the rules and staying compliant in the markets in which they operate?
I'll let the attorney answer that.
Well, I think it's really important to play by the rules. I mean, look what's happening in the vape industry right now from several bad players. I mean, we really have to maybe even pass more stringent laws on testing and things of those natures. Also, with regard to what we do, the construction and development, I think there should be more stringent rules on building these facilities to comply with more pharmaceutical grade types of environments. Because the last thing we need is somebody to keel over and die from smoking bad weed.
Sorry.
Advantages, disadvantages of compliance? Seems like low-hanging fruit for a lawyer to answer that. But.
I'm not sure. I mean, I think that you're asking about advantages and disadvantages
Of complying with state regulations or kind of pushing the envelope.
As a lawyer, all I can say is like following the laws is always a good idea. I mean, following regulations, it's good. And then
unless
if you
they're
want to
federal.
be in the market and stay in the market, wouldn't it make sense to comply with the current regulations?
And there is some gray area, though. I think we've seen as the market's evolved in Florida, there has been room for interpretation as to really what you can do, really what qualifies under some of the statutory laws. And some companies have taken full advantage of pushing that envelope and seeing what works, because if anybody's been paying attention since the early days of this industry, a lot of it is made up as they go. And they, being state regulators, are having to figure this out with on-the-job training that they've never touched an industry like this before, and then are having to learn it the same way many folks in Florida were having to learn it right alongside of them. So once you've secured the right property that fits all the parameters that we've talked about, you've taken all the considerations that we've given today, how difficult is the building process then?
Well, like I said earlier, building on ag lands, cultivation and processing projects is really quite simple from a regulatory standpoint. Building retail dispensary locations, other than the added complication of all the additional security, they're just basically building retail, any type of retail product. It's more. The difficulty is in the zoning, really, and the approvals.
Scott, are you seeing more people redeveloping or building ground up?
Good question, and we honestly have, because of the speed to market, people want to get there. We are really not seeing build to suits from a dispensary standpoint. Everyone's clamoring to try and find existing facilities, and if you can get through the initial permitting process, the zoning process, and God forbid you have to go through a conditional use process, it's already painful enough to go through, and people are certainly, a lot of them are new to maybe the state of Florida or the real estate process, and all of a sudden you find out it takes you 6 months to build out a 2,500 square foot bay. Number one, they look at you like you're crazy to begin with, and all of a sudden you do the conditional use, and that time frame just doubled. That process has been long enough. People are really focusing on the existing standalone. Like I said, we've done everything from funeral homes to restaurants, bank branches, kind of that fit the bill well, and or unanchored center have really worked. But so no, the building just, you've added another year to the process, and the speed that the industry is going right now, we really have not seen that.
And I would just say it depends on the municipality as well. As far as their building department, some are slower than others, some are really quick, some have concierge permitting processes. It just really depends, where you can pay more money and your permits get processed faster. But keep in mind, if you have any type of zoning or entitlements that you have to gain in order to continue with whatever you're trying to build or to operate, you really want to know how long that process is going to take, and you're going to need to talk to somebody who understands that local municipality so that they can give you accurate information about the time frame you need in order to get approved, just so that you can open, let alone go to the building department to pull permits.
Yeah, and I think those are two great points that were made there, especially with building a time in your LOI and then in your contract, not just for due diligence, but separately for governmental approvals. Because if you need 9 months or a year to go through the rezoning process or the conditional use process, those are discretionary approvals, which means these aren't by right approvals. So you could spend 6 months and then get denied at that final hearing. And hopefully you have not just purchased that property prior to finding out that you actually can't operate the use you were intending to operate. Or make sure that you've checked out what building permits you need, business tax receipts, change of use applications. All of that should be built in on the front end of your due diligence so that you have the local government on alert that you are one of the cannabis companies trying to come in, because the last thing you want is them to go change laws and say, we had no clue that you were even coming in as a dispensary because none of your applications indicated it was anything but a pharmacy or indicated it was anything but retail sales. And so that's an excuse we've heard with some local governments changing the rules, and maybe it was a valid one, but you don't want to make that mistake of not putting the local government on alert that this is the intended use you're bringing, so you can deal with those hurdles up front. And a great way also to deal with hurdles that Scott mentioned on the title and the encumbrances on properties, order an ownership and encumbrance report. Like $250. You will know every encumbrance that is recorded against that property. Local governments have no obligation to review title on your property. So you might go and get approved by local government only to find out that you are in violation of a declaration of restrictive covenants, which specifically carved out that the declarant can say no obnoxious, immoral, or offensive uses, and turns out all the other tenants don't like you, and so now you are an obnoxious, immoral, or offensive use, and the fact that you have a zoning letter or a building permit is irrelevant because that's a private encumbrance on your property that you had the obligation to review and to comply with. So make sure you always get that updated O&E report in the beginning. Don't wait to execute a contract, because now you've paid people like Alicia and I to negotiate contracts for a month and a half or 2 months when we find out only during due diligence that you can't even use the property anyway. So do that due diligence on the front end and save yourself a lot of money in legal and consulting fees if you can. If any other words of wisdom before we open it up to the audience for questions, if you guys have any final takeaways? Aside from hire good lawyers, hire good brokers, hire good contractors and builders. Anything else? Love when everybody agrees. All right, we can take some questions now if anybody has them from the audience. I think there's a microphone up front. Everybody's being shy. Sure.
I mean, there's a lot of regulations in place from, and I mean, a big one probably would be security that's required. Everything from the cages to cameras to physical, the security guards on this. So and not that I profess to be an expert exactly in the regulations of this, but they're from a construction standpoint and an opening standpoint, there are a lot of regulations already in place. So I'd probably be a little surprised if it got even stricter.
And I would just say I think it'll evolve based on what happens in the current market. Like if there are any specific issues that come about, I think that you'll see zoning changes that reflect that.
Yeah, and I would agree too. I think we already have a lot of strict regulations. I cannot imagine that rec sales will not be subject to those same security requirements. I presume the state will want that as well. It's just going to be a matter of whether or not total control is given to local governments to regulate them like liquor stores and other vice uses that local governments have full authority to say setbacks, 1,000 feet from schools and 2,500 feet from daycare, nurseries, and things of that sort. I think we're going to see a lot more restrictive local government regulations on recreational sales, again, out of that initial fear of what the recreational industry brings. And so it'll be confusing in the beginning because we have to go back through the entire process again of educating local governments about what recreational sales will mean. But the other nice thing is you can actually put sales tax on it. So maybe some will be friendlier to it because unlike medical marijuana that has no sales tax, you would be able to tax and put that heavy sin tax on recreational sales in the state of Florida.
Good afternoon. From an applicant's perspective, if something changes in terms of when you make a commitment and you checked all the boxes, you got a letter of support, the green card, but then it changes, how or what is the intention?
So I just want to make sure I understand your question. I think it's a good question, but I want to make sure I answer it fully. So you're saying if you've already gotten like certain approvals or that you feel like you've gotten maybe to the midpoint and it feels like it's a go and then something happens, how could you maybe back out of the contract or?
No, but not necessarily. So how you got the support from the city, from the but then there were change election now you're at
For updating your application, is that what you're saying? Being selected and getting a license, is that what you're saying? I don't know exactly what the point scale says, but I would think that some significant change or an inability to secure a property could reflect negatively on you as an applicant, but I'm not sure if the regulations specifically state that.
Yeah, so I think there's two parts to answering that. One is if you want to be fully assured that your property is actually approved, you want to get a building permit pulled. To me, that's the best way that you could try to vest your property and know. It's very hard for the local government to come back after you're already with permits pulled to then retroactively apply new laws and take away your ability to operate a dispensary. Now, you might end up in court with some heavy litigation fees on that, like we've seen around the state, but that still gives kind of the best assurance that you can move forward. And then otherwise, you can typically make an argument to be grandfathered in. We've pulled building permits. I don't care if you ban everybody else after us, but you at least have to let us open because we have, in good faith reliance, relied upon the permits that you have given us, and you cannot now retroactively cause this type of material damage to us. The other part about whether the Department of Health, if they have awarded an application, so If it's not coming out of litigation, which 22 licenses in the state, 5 awarded from a competitive application process, the rest came out of litigation. So I guess the takeaway of the day is hire a good litigator if you'd like to get a license in the state of Florida. But if you put representations in your application, there's a variance procedure with the Department of Health, because they can't hold you to everything you've said literally, right? If you put in certain employees and then that employee refuses to work for you or for whatever reason leaves the state, the Department of Health isn't going to rescind your license because you don't have the dispensary in Boynton Beach like you said you would, or you don't have the head of cultivation as the person who you had identified in your application. The obligation is to submit a variance request for approval to the Department of Health, and you have to show that it is an equal or better alternative than what you had originally put in your application. Because what the department doesn't want is you saying, I'm going to build you a Ferrari factory, and you're like, turns out I'm building a bicycle factory, and so you can't just come in and promise the moon and then come back with the cheapest alternative, because by the way, everybody would do that. So you have to give something equal or better than what you had promised. So if it was, 5 dispensaries, well then go find 5 somewhere else. And the department has been accommodating to those types of variance requests because markets change and issues change between application and the awarding of a license, especially if you applied in, the 2015 time and just got your license this past year. Any other questions? Well, wonderful. Well, if you think of anything afterward, we'll stick around to answer any questions. So thank you so much for your time, and thank you so much to our panelists.
Thank you.
Thank you.
Check 1. Check.